Good morning, good afternoon, good evening, wherever you are in the world. I'm Nicolas Véron. It's my pleasure to introduce this new session of the financial statement series at the Peterson Institute for International Economics. And today we will discuss the sexiest topic of them all, auditing, which many of you know I'm very obsessed about. But before we get to the substance, let me mention that many of you who are on our mailing list received a survey form because we've been doing this series for 4 years now, and we want your feedback on how we can do it better with the support of the whole team at the Peterson Institute of Events and Communications and Meetings. So if you have a moment and you have received that email, please take the survey and give us your suggestions. As I said, we'll discuss auditing today. Saba Qamar studied at the University of Massachusetts and then Suffolk University in Boston. She got degrees in law and in business administration after having studied economics. So she has a full profile to see all the dimensions of the issues we'll discuss today. She joined the staff of the U.S. House of Representatives in 2009, stayed 2 years there, and then became a Foreign Service officer at the U.S. State Department and the legal counsel at the recently created Consumer Financial Protection Bureau, the CFPB, from which she would also, again, detailed to the Congress, to the Senate Committee on Banking, Housing, and Urban Affairs. In early 2015, Saba joined the Federal Deposit Insurance Corporation, the FDIC. She was in secondment from there to the Obama White House for nearly a year in 2016-17. And 2 years ago, in 2022, she moved from the FDIC to the U.S. Public Company Accounting Oversight Board, the PIIE. We will hear that acronym again today, where Saba started a new department, a new function of investor advocacy. Not exactly that the PIIE had never had any contact with the investor community before, but they decided to give more structure to their interaction with the investor community. So she will explain that. Charles Henderson studied law at Manchester Metropolitan University, from which he graduated in 1979. He became a chartered accountant and exercised the profession in various firms, including at Touch Ross, which later became Deloitte. In 1994, he joined Perpetual, an investment management firm, which later in 2001 was purchased by Invesco. So Charles stayed 25 years in that firm, so with a very deep experience in investment management and especially equity investment and the associated issues of corporate governance and stewardship. He has long been on advisory panels and committees of the Financial Reporting Council in the United Kingdom, which is kind of the functional equivalent of the PCAOB, at least as far as audit supervision is concerned. He has also been in the Corporate Reporting Users Forum, which is a group that brings together a number of investors and other users of financial reporting, including as chair of its ESG, environmental, social, and governance committee or body. In August 2021, Charles became the chair of the UK Shareholders Association, which is an advocacy group for the interest of investors, which was established in 1992. So we have a very investor-centric panel today. And with that, Saba, over to you. I will try to share your slides.
Thank you, Nicholas. Good morning. And thanks again for the warm welcome. It is a pleasure to be here today. Before I continue, please note that these remarks are provided in my official capacity as the Public Company Accounting Oversight Board Investor Advocate, but the views expressed are my own, and they do not necessarily reflect the views of the board members, or other staff. The title of this event is Can Auditors Better Serve Investor Needs? Based on what I hear from public company investors across the country, the short answer is yes. To begin to see why, I will start with some brief history before returning to the present. What now seems like ancient history, creating the PCAOB, my current organization, was a response to a high-profile corporate accounting scandals of the 1990s and early 2000s. In accounting scandals associated with Enron, WorldCom, and other companies before and since, the financial statements depicted an overly rosy picture of a company's financial position through creative accounting, earnings smoothings, inflated revenues and assets, understating expenses and liabilities, off-balance sheet transactions, special purpose entities, and other tricks and traps to fool investors and the market. The collapse of Enron in 2001 is a stark example of the importance of auditors in cutting through the hype and protecting investors. For those who are unfamiliar with the history of Enron, Enron was a US energy company that rose to the 7th on the Fortune 500 list. In 1996, just a few years before its bankruptcy, Enron's chairman, Ken Lay, described the company's vision as becoming the leading energy company in the world. The press at the time wrote about its entirely new business in which highly paid power marketers use gigabytes of computerized market information to sell gas and electric power across the country. To our ears today, this may sound antique, but at the time, Enron was a technology-powered corporate darling. Unbeknownst to the investing public, its blue-chip reputation concealed earnings fraud, significant bad debt, and other manipulations. When the scandal broke, the value of Enron shares plummeted, investors lost billions of dollars, and 20,000 employees lost their jobs and had their futures upended. Following Enron's collapse, one of the largest accounting firms in the world and Enron's auditor, Arthur Henderson, collapsed after it was indicted by the Department of Justice in 2002, and its 85,000 employees worldwide were adversely impacted. As a result of all these corporate scandals, Congress passed the Sarbanes-Oxley Act, which created the PCAOB and tasked the organization with the mission to protect investors, all in an effort to safeguard against accounting financial failures like those in Enron and WorldCom. To meet its mission to protect investors, PCAOB has 4 primary duties. First, it registers public accounting firms that prepare audits, audit reports for issuers and SEC registered broker-dealers. It also establishes auditing standards. Third, it inspects registered public accounting firms, audits, and quality control systems. And finally, it investigates and disciplines registered public accounting firms and their associated persons for violations of specific laws, rules, and professional standards. In that regard, last year, the PCAOB inspected auditing firms around the world, which requires a high degree of skills and expertise of my colleagues. We have published reports of those inspections, and I highly recommend that you take a look at them. Consistent with the mission to protect investors, our current board, under the leadership of Erica Williams, has been highly proactive in seeking to improve audit quality. In addition to creating the Office of Investor Advocate, the board reconstituted the Investor Advisory Group and started implementing its strategic plan centered around modernizing the PCAOB standards, enhancing inspections, and strengthening enforcement. This is why the creation of my role and the Office of the Investor Advocate are part of the whole of PCAOB effort to protect investors. Given the new nature of the office, let me tell you a bit about what we do. Since starting this role, we have been focused on 3 key priorities. These include collaborating and coordinating with investors, such as large institutional investors as well as retail ones, and investor advocates. The office also publishes educational content to raise awareness about the role of the PCAOB and its key initiatives. These are intended to simplify highly technical audit matters and make them more accessible to investors. Second, we elevate the voices of investors at the PCAOB. The office engages with investors and investor advocates regarding the impact of the PCAOB's regulatory activities on investors. The office helps identify additional opportunities for strengthening investor protection, and provides policy feedback on the PCAOB's agenda. We have a robust standard setting and rulemaking docket, and I highly encourage the listeners to please take a look at it. Third, the office supports the PCAOB Investor Advisory Group, which is composed of a broad range of investors and investor advocates with deep expertise and experience. What I hear from investors is that they have taken comfort from the fact that financial statements are audited. Providing that comfort depends on the integrity of auditors and the audit process. I'll focus on some data about the work of the PCAOB to protect investors and enhance audit quality, which brings me to audit standards and some particular ways that the PCAOB is responding to investor needs. For example, there were more formal actions on standard setting and rulemaking in 2023 than any year since 2013, almost 2 decades. Many audit standards were first adopted by the PCAOB in 2003 based on pre-existing standards written by the audit profession. The PCAOB adopted them as interim standards, and many have not been significantly updated since. The world has changed significantly since 2003, and in 2022, PCAOB set out its strategic plan, the effort to modernize audit standards for today's needs. Yesterday, the PCAOB adopted 2 updates to its standards that put investors' needs at the forefront. First, PCAOB adopted a new standard on general responsibilities of the auditor. The new standard, which enhances and consolidates a group of interim standards, clearly reaffirmed the fundamental obligation of auditors to investors, echoing a touchstone opinion of the US Supreme Court, that auditors have fundamental obligation to investors. Second, the board also adopted a new standard for audit firms' quality control system. As in other areas of business, quality control is about improving the outcome and consistency of the final product. Effective quality controls systems for audit firms are important to investors because of the need for informative, accurate, independent, and compliant audit reports. Improving the QC standards will lead firms to improve their QC, which should result in a more consistent compliance with applicable requirements, which ultimately better serve and protect investors. Likewise, the board prioritizes enforcement efforts that address those issues that pose the greatest risk to investors and are most likely to deter improper conduct. The total penalties imposed by the PCAOB set successive annual record in 2022 and 2023. Last month, 2024 broke the record yet again with 34 million in total penalties to that point. Also last month, PCAOB announced the largest civil money penalty in PCAOB's history in connection with widespread exam cheating at an audit firm, including by senior firm leadership. This pattern of exam cheating, however, is not isolated at the one firm. 9 registered firms have been sanctioned by the PCAOB for exam cheating since 2021. PCAOB regularly inspects audit firms and select audit engagements to assess each firm's compliance with the PCAOB standards and rules, as well as certain other applicable regulatory and financial requirements. Of the public companies audits inspected in 2022, PCAOB inspectors observed that approximately 40% had at least one deficiency where auditors failed to obtain sufficient appropriate audit evidence to support its opinion. One final plug before I turn things over. As the PCAOB's inaugural investor advocate, I encourage investors and investor advocates, as well as academics in the audience, to reach out to my office if you have any questions or would like to share your perspective. Protecting investors is at the heart of our mission, and we cannot do it without hearing from you. Thank you for your time, and thank you, Nicolas.
Thank you. And let me stop sharing this. I should say that I had a little bit of a shaking screen at the beginning, but that's now been fixed. And with that, over to you, Charles.
Okay, thank you, Nicolas. Very interesting outline, Saba. Thank you for that. My comments are going to be personal, like Saba's as well. They cannot be attributed to the UK Shareholders Association or the Corporate Reporting Users Forum, unless you can find some public documents that repeat what I'm about to say. I used to be an auditor before I joined the investment management company, which ended up being Invesco. And it was there that I returned to an interest in corporate reporting, including governance, auditing and sustainability reporting. And that was mainly because the fund managers I used to look after, I found out that they actually relied on mainly annual reports for the information they poured over for their particular investments. And they used to collect the information over time. And they relied primarily on the financial statements because they were audited. The narrative reporting they did look at, but they probably didn't have much time to spend going through it to try and find out the nuggets of information that they needed. As a UK Chartered Accountant, I continue my interest in corporate reporting, especially through the Corporate Reporting Users Forum and the UK Shareholders Association policy team. My starting point is probably similar to Saba's, which is the short answer is yes, that auditors can better serve investors' needs. But I'm probably going to come at this from a completely different angle, because I believe that it's the entities preparers that should be better serving investors' information needs, not the auditors. The auditor's main responsibility, as Saba has pointed out, is providing a certain level of comfort that an entity's reported information is reasonably trustworthy. However, auditors do need to help the entities better inform investors. They need to push the entities to report better. They should not, auditors should not be helping entities with their compliance requirements, because in my view, this will jeopardize their independence and objectivity. So the information needs of investors is the responsibility of reporting entities. I'm not sure they do a particularly good job, and I'm basing that on what I hear back at Corporate Reporting User Forum meetings, and also from my UK Shareholder Association members. And I think it is mainly because the reporting reflects the International Accounting Standard Board's disclosure problem, which they've consulted on, but I'm not sure they're taking it any further because I'm not sure they can do anything about it. And the disclosure problem is that most entities provide too much irrelevant information, not enough relevant information, and the information they provide sometimes is badly communicated. And I think partly because an entity's starting point is the compliance checklist they go through. So most annual reports are basically a completion of an annual checklist of compliance requirements. The problems, the audit expectations gap problems, I think, starts with the relationship between an entity and its auditor, because the auditor tends to see their engagement contract with the entity and not their real clients, the shareholders of the entity. The entity pays the auditor on behalf of shareholders and therefore controls the relationship. The auditor tends to therefore think about what the entity wants as a customer, rather than what the shareholders want or need. Then the entity looks at the auditor for technical advice to make sure they're meeting their annual reporting obligations and to get a clean audit report. The problems are then increased by the entity wanting to look good to all their stakeholders. Therefore, annual reports are created with presentational objectives, i.e. making the business look attractive, rather than the substance, which is business reporting to shareholders about how they used shareholders' capital and how they performed. So the tendency is to load annual reports with loads of information that will not be relevant to investors and will obscure relevant information for investors. These problems are then topped by auditors and investors not engaging and communicating with each other, despite them being the two main relevant parties in an audit. So I think entities can improve the audit expectations gap situation by thinking for themselves, i.e. not relying on other people to advise them, deciding what in any reporting period is relevant and focus on this, preferably leaving out anything that is immaterial and might obscure the key information. Defining what relevant means, usually using the International Financial Reporting Standards definition of material, for accounting and sustainability standards, and engaging with their shareholders, which I don't think they do a lot of, to find out what they believe is relevant. And then producing an annual report that is a business report serving investors' needs. Auditors can improve the expectations gap situation by recognizing who their actual clients are, i.e. the investors, shareholders of entities. Engaging with those investors to find out what they think is relevant and would become key audit matters, material reporting concerns from an investor perspective. Setting a materiality perspective that is qualitative as well as quantitative. And for me, that is information that is price sensitive, which is why the IFRS definition of materiality is worded the way it is, i.e. relevant to investment decision making. And then producing an audit report, a report that is clear, concise and understandable, i.e. with clear opinions, informative information to investors on materiality and key audit matters, material issue, and those are probably two things that they do report on, but the rest I think I'm going to find that no audit report ever reports on, which is material issues where entities and auditors have disagreed and how they were resolved, and clear information on who they are answerable to, and therefore who they have liability to, and what the limitations of that liability are. And finally, investors can improve the audit expectations gap situation by understanding exactly what an audit is supposed to do and recognizing its limitations in providing entity-specific information. The entity should be providing the information, not the auditor. Investors should engage with entities and their auditors in the first instance, where they have concerns about an entity's reporting. And if that doesn't go anywhere, then they should report the issues to their jurisdictional reporting and or auditing regulators. Thank you.
This was great. I think all of the people in the audience who have had interaction with auditors can see where your requirement shares have been met or not in their experience. So that's very concrete. Let me start with a few questions coming back to you, Saba. Charles, in his remarks, put a big emphasis on the difference between financial and non-financial information, and these days that also includes ESG information about sustainability-related disclosures. Can you give us a sense of how these different elements, financial information, narrative information, sustainability-related information, play in your job and what you hear from investors in terms of their sensitivities to their, in a way, relative importance? That's
a first-rate question, Nicolas. Thank you. It's Thank you for that question. And investors are definitely in our jobs, in my job, in our interactions with investors, ESG is a big focus, especially climate. We in the US, as you know, the SEC oversees the PCAOB. The SEC just finalized its rule on climate reporting, and the PCAOB will have a role. We're assessing it. And once a final decision has been made, I think that will be out. Now, going back to what you're saying about investor sentiments, as I said, it's an important issue for investors, and we have been talking to them. We're also, as far as the PCAOB is concerned, it's not just climate. Every time, at the end of the day, auditors provide reasonable assurance, right? So if a company is misrepresenting their, climate commitment, net zero commitment, and their financial statements present a different story, I think that is where the role of the PCAOB in climate. It's not, I don't see it any differently than other types of misrepresentation, material misrepresentations, right, on financial statements. If a company is misrepresenting information, whether it's in climate or other forms of depreciations, auditors are supposed to be flagging that, and if they're not, that is where the PCAOB has a role, and that is where the PCAOB, through its authority, whether it's in inspection or enforcement, will hold them accountable.
One reason why I asked this question, obviously, is you're in the US, and in the US, ESG reporting has become a bit of a political football. In a way, the previous session of this series was on sustainability-related disclosures with Hugh Lloyd of the International Sustainability Standards Board. My impression is that in the public space, the willingness of investors to bring forward these sustainability-related concerns has decreased substantially in the last year or two, given the political controversies around it. And obviously, we're in an election cycle. But how does that affect the way they interact with you as a regulator, and how do you see the salience of this ESG issue evolving in the US context, given this broader environment?
So, I mean, I see. So the mission, and this may sound really like not a soundbite, but a very boring response. The mission of the PCAOB is to protect investors, and we respond to the needs of investors. What they and the core mission is to make sure that auditors are providing accurate, timely, and informative information to investors. It could be, as I said, could be ESG or some other forms of information. So at least at the PCAOB, we're not driven by the politics of the day. We're focused on the mission, which is to protect investors. So those issues are non-political, both sides of the aisle. They are focused on, making sure that retirement savings are safe from the next Bernie Madoff and from the next Enron, So I think
I understand they're not political from your perspective, but I'm interested in the investor's perspective. Do you see more or less demand in the last year or two from investors for, an active role of the PCAOB in that area?
I mean, we have had engagement from investors. There are definitely some who are more vocal about ESG than others, and then there are those who were, vocal, let's say 2 years ago, but are less so. I mean, we have seen this in the Climate 100 network, the initiative, where a couple of big names have dropped out. So that's definitely something that is changing, and we're monitoring it.
Nicolas, can I
Sure.
interject? One of the things that the Corporate Reporting User Forum ESG subgroup has recognized is that the ISSB sustainability standards are going to be quite slow to be adopted because of jurisdictional adoptions or endorsements, etc. So it's going to be pretty difficult for auditors force their or sort of pressure their entities to report on the sustainability standards that are coming forward. And there's only really one, which is the climate one, but there's also a general one. So hopefully that goes wider, as Saba has indicated, beyond climate. But one of the interesting things that Cruf ESG has noticed over the past few years is it's been following something called Carbon Trackers annual report on the top 160 greenhouse gas emitters in the world, and how little they mention climate or anything to do with climate or greenhouse gas emissions in their audited financial statements. And this is surprising, considering that the International Accounting Standards Board, and I know this probably doesn't apply to the USA, but it does outside the USA, wherever IFRS standards are sort of implemented. The IASB has said that if climate-related information is material from an accounting point of view, there are lots of accounting standards that require these entities to report. And slowly they are increasing their mention of what has now become climate accounting in their financial statements. But it seems to be very difficult to get them to do so, and auditors are not pressuring them to do so.
What you're saying, if I hear you correctly, is that there's a race with regulation and legislation here, right? So, the framework for enforceable standards is still in its infancy, or did I get that wrong?
No, that is right on the sustainability side, Nicolas, but it's not on the accounting side. The accounting side, according to the International Accounting Standards Board, it's very clear that the accounting standards in existence will require climate-related information to be reported if it's material.
Charles, I also think this goes back to your earlier point about the expectations gap, whether it's ESG or other areas. I think investors have this misconception about what an auditor is able to provide versus what they actually do provide.
Yeah.
So I think that's just like any other area in this space. There's this huge expectations gap.
Yeah, and I think for example, in the UK, us investors were all very hopeful with the way that the regulator, the auditing and accounting and reporting regulator and the government were going, until they abandoned it, not least because there's an election coming up, that they were pushing for something called an audit and assurance policy to be produced by entities, which would cover engagement with investors on exactly why they wanted audit and assurance of whatever an organization was going to do, and that would set out the policy around engaging with investors, etc., around audit planning and things like that, so that between the entity and the auditors and the investors, there would be a collective view as to what needs assuring or auditing, and what level of assurance should be given. But unfortunately, that seems to have disappeared.
Since there's a chance of this reform being revived, or is it the end of it basically in the UK context?
My limited understanding, Nicolas, is that it could be revived because I understand that Labour, if they do get into government, would want to go back and try and put in what was originally thought through.
Interesting. We'll follow that space. We have a question about how auditors could be incentivized to better take into consideration the entities, owners, and their objectives apart from audit or regulation. And this also brings me to introduce the issue of auditor liability. Saba, can you give us a sense of how the debate on auditor liability has evolved, at least in the US context, and if you can comment on it also internationally, in the last 10, 15 years, because that has been a hotly debated issue. Are the auditors liable for the quality of financial information provided? What has changed in that space, and what are the key elements of the currently applicable jurisprudence?
So thank you for that question. It's I can't comment on the international space, but I can give you my perspective on auditor liability in the US. Look, as Charles said at the beginning of this conversation, it is the company's internal auditors whose job it is to make sure that it's their primary responsibility to ensure that information is accurate and timely. However, that does not exonerate the external auditors for verifying the information that is presented to them, right? Because that is where trust in the financial reporting ecosystem comes from. So coming back just in a normal setting, like any other profession, they may be liable if they're negligent, they're acting in bad faith, they're aiding and abetting fraud. I won't get into the technical details of the legalities because I don't have a lawyer with me, but it's in the US, it's still very hard. And we have in areas where where auditors are involved in aiding, abetting fraud, in being negligent, we have the tools, our enforcement tools where the PCAOB can go and through our inspections process, through our enforcement authority, they can go and hold bad actors accountable and deter that kind of behavior. But it's pretty hard, I would say, in the regulatory status. Now, for private, as I said, I'm not speaking in my legal capacity and I don't have a lawyer, but I would imagine there are lawyers, the plaintiffs bar, the attorneys who bring lawsuits on behalf of investors, if you talk to them, they probably will tell you that it's not the easiest thing to do, but there have been cases where auditors have been held accountable, and that is where this conversation is helpful, because we are getting to a point where these statements, there is a decision out there, the BDO trust decision from the Second Circuit, where the court said investors should not have relied upon the auditor's opinion because it's not very helpful. Now, do we want these opinions from auditors to continue to go down in that trajectory where they're not helpful to investors, where they can be meaningfully relied upon, or where we want them to be robust and they play their role? So
is that a legislative matter with reference to the decision you just mentioned, or is that a matter for future jurisprudence?
No, it's a court case, and we'd be happy to share information. But it's basically in the Second Circuit, the court decided that investors should not have relied upon the opinion. They were opinion of the auditor, external auditor, because there was basically no meaningful information. It was not reasonable for the investors to rely upon the opinion of the auditor. And just looking at, obviously, the investors are appealing it. The SEC filed an amicus brief. Investor advocates filed an amicus brief because it's making audits irrelevant. It's basically, if that decision holds, audits will become irrelevant. If investors can rely upon the information that is provided by the auditors, like unqualified passage of a financial statement, if you look at that, I look at some of these things through the lens of my parents, right? If they look at a financial statement, if they want to invest in a company, as retail investors, regular people who are not sophisticated, who do not have the resources, and they look at the company's website where the auditor are saying, we have given them an unqualified opinion that they have passed the audit, but then we have this decision where it's saying it was not reasonable because the investors are not giving them anything. I think that is where like all these issues that you're discussing, whether it's financials, non-financials, the assurance, reasonable assurance, 100% assurance, all of that come into play because in that, yes, it's the role of the.
Conversely, you mentioned jurisprudence, I don't know how recent, where auditors have been found liable for issues. Can you detail that a little bit more for us, and how recent was that, and give us a sense of the cases?
So are you asking me? I will have to go back because I don't have those specific questions, but I will have to go back and circle back.
Tell us whatever you remember.
So I mean, in cases where there are where there are where auditors are aiding and abetting fraud, for example, this is not in the US, but in Wirecard, E&Y was involved, actively aiding and abetting. And again, these are legal terms. I don't want to use them in a way to imply certain meanings, but it's clear that auditor E&Y did not do its job as far as Wirecard was concerned. This was obviously in Germany, not in the US. We have seen it with Arthur Anderson, right? Before the PCAOB was created.
That
right?
was long ago.
Yeah.
We have a question from Pierre Raffi about that. Did the PCAOB have any jurisdiction on Wirecard? Any why?
I mean, PCAOB has jurisdiction over auditors that inspect, US that are registered in the US.
So was there a US element to Wirecard that the PCAOB had jurisdiction over, or was it entirely outside of its role?
I think it was I mean, I will have to get back to you on this one, but I think it was entirely outside.
So to you, Charles, on this issue of auditor liability, how do you see the landscape evolving, and has there been more protection of investors through that mechanism, less so in the last decade or two? What is the direction of travel?
The impression I've got, Nicolas, is it's remained the same, but in the UK, it was pretty much set by a court case decision, and I think the court case is called Caparo, where the court decision was it very narrowly defined what the auditors, who the auditors were responsible to, and I think it was the shareholders of a company. So the person who brought the case in Caparo, who had acquired an organization and felt that they should have been able to rely on the audit of this organization. And it turned out that the information provided by the acquired entity was wrong, and which this person argued the auditor should have found out and reported. But the problem was that this person, while they acquired the entity, they weren't a shareholder of the entity. And I think I'm getting the facts right on this. And therefore, the court case decided that that person, the acquirer of this entity, couldn't rely on the auditors. Only the shareholders could. And I don't think that's changed in the UK. But I think there's a lot of, and it's past the expectation gap here, I think. A lot of people think the auditors are responsible for far more than they actually are. And then when something goes wrong, like Wirecard, they go, why aren't people going after the auditors and getting money off them, type of thing. Now, in most cases, in my mind, that's because the auditors have deeper pockets than the management, who are ultimately responsible for all these things, have. So people go after the auditors and find it's really difficult when they should be going after management. And in a way, it should be management that are made to have professional indemnity insurance that can pay up when something goes wrong.
It's also a bit mind-boggling, right? If auditors opinions mean nothing and if they cannot be held liable, why do we need auditors at all? Should we get rid of the auditing mandate? What do you think, Charles?
No, because ultimately investors rely on the assurance that auditors give to an entity's information, especially their financial statements, which are audited. That information, which is heavily relied on in the investor community. And to a large extent, Nicolas, I think audits do their job well, and therefore shareholders don't have to go after auditors for not doing their job. And unfortunately, it's the few exceptions, like some of the ones mentioned, which give rise to the idea, like most things, that there's a problem. So, but they're sort of a few instances as opposed to the majority of instances. And when you consider that thousands of audits are happening and providing the assurance and confidence in market information, then I don't think if you took away audits, that would disappear.
I agree with Charles, because overall the system is working when it comes to providing trust in the market. You know, for the most part, auditors want to do the right thing, like any other profession. There are some bad apples, you know, and that's to be expected in, you know, in a profession that has hundreds of thousands of individuals. If one were to get rid of, you know, what investors want to be in a situation pre 1933, where there were no audits were not mandated. I don't think that's the case. I think the system works when there are external auditors providing that assurance, and works best when they are providing information in a way that's more meaningful. I think there are definitely areas of improvement. That is where we need engagement from investors, investor advocates. And while you're talking to Charles, I did look up. So E&Y is going back to Wirecard. It was E&Y's Germany's affiliate. It was not registered in the US. So although E&Y is a global company, they have to be, there are affiliates, and they have to be registered in the US with the PCAOB in order for the PCAOB to bring in enforcement action. So in this case, this was entirely a German operation, which is why the PCAOB was not involved. I'm sure there were, if there was a role for the PCAOB, they would have aggressively pursued it, because at least this board has made it clear that they're not going to tolerate bad behavior that harms investors and tries to where investor trust in the market is shaken. So I wanted to make sure.
I mean, we have a global market here, and last time I checked, firms like not particularly EY, but the global networks, they present themselves as global networks. They present themselves as a global brand, seamlessly integrated global services. So you're right. I mean, technically, they're separate partnership and they're not dependent from one another. And there's a very intricate legal construct to make sure the US partnership will not be liable for the behavior of the German partnership. But there is something that doesn't seem completely consistent there. So can you tell us more about international cooperation? There's a question from Pierre Raffi, and what do you do to ensure an element of consistency across borders, even when the lawyers have done a good job to ring-fence liability?
So we have an Office of International Affairs. My colleagues work very closely with foreign regulators to ensure that there's cooperation and coordination. In this specific case, it's the issuer's listing location that I think determines the jurisdiction, and not the global network issue. I mean, Wirecard was a German company, and that is why E&Y's involvement in Germany did.
So if it had been a US company listed in the US, I think I know the answer to that question, no matter who was auditing it, be it a German or Malaysian or US auditors, that would have been under the jurisdiction of the PCAOB, correct?
Yeah, that's correct.
So how does the PCAOB do that if the auditor is in Germany?
So, I mean, as you see, we have enforcement actions that are made public all over. Just recently, the one that I mentioned in my remarks with the $34 million in penalties in the exam cheating, this was a Dutch auditor. Like, if the goal of the PCAOB is pretty simple, right? Ensuring that auditors are doing their job. And
PCAOB concretely get to a Dutch auditor and has this impact and enforcement capability outside of US borders.
so they work closely with foreign, I don't want to get into the technical details of our,
I would like you to go into the technical details. That's what we're here for.
They work closely with the foreign regulators, in this case the Dutch regulators. They also the PCAOB has, if a company is listed in the US, they're inspecting US listed public companies, SEC registered broker dealers, and they're registered with the PCAOB. The PCAOB has legal authority to inspect and bring enforcement actions, and that's how it works. In this particular instance, I'm assuming, I have to go back, but I'm pretty sure they were doing work for U.S. listed publicly, U.S. listed companies, which is why the PCAOB was able to bring that, to sanction them and impose penalties.
Nicolas, can I just add that from my experience with the Financial Reporting Council is that I know that jurisdictional regulators have arrangements with each other, because I can remember the PCAOB and the FRC sort of exchanging ideas on inspections when I was on the Audit Quality Review Committee at the FRC, for example. So there are connections between the regulators that help with this.
There's also an international organization, the International Forum of Independent Audit Regulators, IFIAR, whose secretariat is, I think, in Tokyo. Can you tell us more about that and if it has made a difference in this world of auditing enforcement, Saba?
So, I mean, as I said, we have an Office of International Affairs. They work very closely with IFIAR. Our board members are heading some of the steering committees. It's really important for, companies are global, auditors are doing work all over the world. Some of my colleagues say the sun never sets on the PCAOB's inspections team. I personally think it has made an impact in terms of, coordination and collaboration. It's important to exchange ideas, share information, and that is exactly what IFIAR is intended to do. So far since the creation of the PCAOB, there hasn't been a big global Enron scandal, and I think that it goes to basically show how these global regulators through different forums have been working closely with each other. So, I mean, that's just my personal
view. Maybe. I'm curious about a different topic, which is the corporate form and shareholding structure of auditors. So there has been a major development in that space because traditionally auditors, by regulation, were professional firms, professional partnerships with individually liable partners, and then there have been reforms enabling different structures. And recently, Grant Thornton, which I think is the number 6 or 7 global audit network, so not one of the big 4, but basically in the next tier, became majority owned by a private equity company, Mountain Capital. And I think another big US firm, Baker Tilly, went there before. Pardon me. So now we get major audit firms, which are basically joint stock companies, shareholder-owned companies, which are no longer professional partnerships. Does that make a difference? Is it a positive or negative difference? How should we think about that? Maybe Saba first and then Charles.
So, I mean, my personal view is, look, this issue needs to be, looked at closely, right? It's we have seen the private equity getting into auditing. There is a lack of competition, especially with the big 4. I mean, that is an issue that that a lot of investors and others have expressed their concerns about, and that the Big Four could use more competition, and investors would be better off probably if there was more competition. Now, what role does the different structure plays? It's yet to be seen. The information is still too new, but I think it is something that we are closely monitoring. And
use as a trade-off the intrusion of quote unquote capitalist shareholders could resolve the long-standing competition problem. At the same time, that means getting rid of the cultural attributes that come with professional partnerships. Is that the trade-off?
That could potentially be, right? That could potentially be. And then, I think, like, are they going to be focused on cutting costs? Are they going to be focused on ensuring that, audit quality is enhanced? It's yet to be seen, right? But still, this is a new territory, and the PCAOB is definitely paying attention to it. I'm personally interested in it because it's something that I do think, on one hand, as you said, it's a capitalist solution to the lack of competition in this space. But on the other hand, at what cost? Is it going to enhance audit quality, or is it going to be, let's just get rid of people, let's try to automate certain processes, and maybe things go downhill. So it's yet to be seen. But I think we're definitely in a more interesting.
Very interesting. Charles, what do you think of that? Is it good? Is it bad?
Too early to tell, Nicolas, from my perspective.
So you agree?
I think partnerships are personally, I think the partnerships are better, because then you've got people who are holding each other to account. For example, if it's a corporate structure with a private equity being a major shareholder, it will be down to the way the shareholders hold the entity, the auditor, to account. I personally don't have a major concern about audit competition. I think audit is something that's sort of difficult to work out how you compete, because it's such a regulated process that the competition comes down to the quality of the audit, and the higher quality requires probably higher costs, and as a result, investors should be prepared to accept those higher costs.
No, 100% agree, Charles. We don't want to encourage competition at the cost of business, at the cost of outcome quality, right? Definitely. Competition should be on quality, not just for the sake of competition, for the quality to go down. So I definitely agree with that.
How do you measure quality, Saba? I know the PCAOB has been thinking about this a lot. Sorry, Charles, go ahead.
No, I was going to say that's probably another one of these sessions, Nicolas, is to find out how to measure audit quality. I think a lot of people are struggling with it, including myself.
Saba, what's your answer?
I think it's both. It's one of those things where it's both qualitative as well as quantitative, and it may be hard to describe, but it's not hard to see once you see it, right? Like if you're looking at an audit, an audit where the auditor has followed, policies, procedures, PCAOB, shameless plug, PCAOB's QC, the new proposal that has just come out. They follow our standards, our rules, as well as their own internal policies and procedures. I would think that should at least provide some appropriate level of comfort to investors that the audit was that it's a quality audit.
Okay, so if they tick all the boxes, it's all good.
I don't necessarily think it's a tick the box exercise. That is why there is the fairly presents, and the reasonable assurance comes into play, right? Like, to me, it's an art, not a science. It's not just check the boxes, auditors, like there are conversations that auditors have that, normal investors are not privy to with management. There are things that there's information and cues that they get from being in the room, as so to speak, that, external individuals do not. So I see their role as not just, public interest role that is more of an art than a check the box exercise. And I hope they see their role in the same light.
In the
Last
UK,
word, yeah.
pardon?
You have the last word.
I was just going to say, in the UK, audit firms have to, if they're large enough, and I can't remember the size requirement, to issue an annual transparency report where they have to report on audit quality. Not a lot of people use it.
That note, indeed, audit quality measurement or assessment should be the matter of a future session. Maybe we'll do that. Our next session will be in a bit more than 2 weeks' time on May the 30th. We'll have Sam Woods, the chief executive of the Prudential Regulation Authority, which is the supervisory arm of the Bank of England, and we'll discuss how financial regulation has evolved in the UK, indeed. So maybe I will quiz him about what you mentioned, Charles, about abandoning this project on auditing regulation since Brexit, of course. In the meantime, I want to thank very warmly our two speakers, Saba Qamar and Charles Henderson, for a very thought-provoking discussion. We'll come back to this theme of auditors and the quality of audits, because it's so important. Thanks to everybody, and have a great day.
Okay, thank you.
Thank you.
Bye, everyone.